Good day everyone, we are Group 1 and today we will be presenting our case study on Philippine Bar Association versus United Construction Company Incorporated, 1F Nakpil&Sons, 1J Carlos and the Court of Appeals case. Let's begin by exploring the key points of this case study. The Philippine Bar Association or PBA wanted to build an office in Intramuros and hired 1F Nakpil&Sons to design it, and United Construction Company Incorporated or UCCI to build it. The project was undertaken on an administration basis with UCCI's President and General Manager 1J Carlos recommending this arrangement. The plans and specifications were crafted by 1F Nakpil&Sons, a reputable architectural firm. So, the building was completed in 1966 but suffered major damage after an earthquake in 1968. The earthquake on August 2, 1968 was unusually strong, causing significant structural damage. Temporary repairs were made, but subsequent earthquakes in 1970 worsened the building's condition, eventually leading to its demolition. PBA sued UCCI, claiming poor construction and contact violations. PBA alleged that UCCI failed to adhere to the approved plans and specifications, resulting in construction defects that made the building vulnerable to the earthquake. UCCI countered, blaming 1F Nakpil&Sons for faulty designs. UCCI filed a third-party complaint against the architects, asserting that damage was due to defects in the plans and specifications provided by 1F Nakpil&Sons. A court-appointed commissioner found both the construction and designs defective, leading to shared liability. Commissioner Andres O. Hizon concluded that the damage was caused by defects in the architectural plans, so deviations from these plans during construction, and a lack of proper workmanship and supervision by UCCI. So the Supreme Court ruled that both UCCI and the Nakpils were responsible under Article 1723 of the Civil Code since the building collapsed within 15 years. The court emphasized that the earthquake, while an act of God, did not exempt UCCI and the Nakpils from liability because their negligence was proximate cause of the building's inability to withstand the disaster. So both parties were held solidarily liable for damages, with the award to PBA increased to 5 million pesos plus attorney's fees.
Relevant article and civil codes. Article 1723 hold engineer and architects liable for building defect within 15 years unless due to the force majeure and unavoidable disaster. Article 1117 negligence in obligation results in liability since the collapse was partly due to construction flaws, not just the earthquake. Article 1267 excuses obligation when performance become impossible, but the court rejected this, arguing that earthquakes are forcible and the building should have been designed to withstand them.
Historical background. Back in the 1960s, Manila was expanding and organizations were constructing more buildings, but regulations weren't as strict as they are today. Earthquakes were not rare, yet earthquake proofing wasn't always prioritized. This case set a precedent for holding architects and contractors accountable for unsafe buildings, reinforcing the importance of quality construction and compliance with engineering standards. And for the issues, number one, who should be liable for the building's collapse? The architects who designed it or the contractors who built it. Number two, does an earthquake count as force majeure that removes liability? Number three, did UCCI deviate from the approved construction plans leading to structural weaknesses?
The Supreme Court ruled that both the architect Juan F. Nakpil&Sons and the contractor United Construction Corporation were responsible for the collapse of the Philippine Bar Association or PBA building. The key reasons were, the first is, the earthquake was not the sole cause. While an earthquake damaged the building, experts found that there were defects in both its design and construction. Second is the design flaws. The architects Juan F. Nakpil&Sons failed to ensure that the building was structurally sound and resistant to foreseeable disasters like earthquakes. Third is poor construction. The contractor, UCCI, did not follow the approved design plans and used poor workmanship, making the building weaker. The last is liability under the Civil Code. Since the building collapsed within 15 years of completion, both the architect and the contractor were held accountable under Article 1723 of the Civil Code. This article states that architects and engineers are liable for building defects within this period unless the damage is caused by an unavoidable disaster. The court rejected the first major argument because earthquakes in Manila were predictable and the building should have been designed to withstand them. The final decisions, both Juan F. Nakpil&Sons and UCCI, were jointly liable for the building's failure. They were required to pay damages to the Philippine Bar Association for their negligence. This case set an important legal precedent in the Philippines, emphasizing the accountability of architects and contractors for safe building design and construction.
For the number one question, why did the Philippine Bar Association, or PBA, still file a case even though the earthquake played a big role in damage? So the PBA filed the case because they believed that the damage wasn't just caused by the earthquake. They suspected faulty construction and design made the building weaker than it should have been. Even if an earthquake is a natural disaster, buildings are supposed to be built to withstand them, especially in a place like the Philippines where earthquakes are common. The Supreme Court agreed that both the architects Juan F. Nakpil&Sons and the contractors United Construction Co. Inc. had a role in the collapse because of poor design. Deviations from the plans and bad workmanship. Basically, the PBA wasn't just blaming nature. They were arguing that the building had been properly designed and constructed, it would have been so damaged in the first place. So, if the odds weren't perfect, they had a solid reason to fight for accountability. For the summary, for the summary, the Philippine Bar Association, or the PBA, wanted a building, so they hired one F. Nakpil and Sons to design it, and United Construction Corporation Inc., or UCCI, to build it. Everything seemed fine until a 1968 earthquake hit and severely damaged the building. PBA was mad and sued UCCI, saying, you built it badly, so but UCCI said, not our fault. The architects made a bad design, so who was really it to blame? The Supreme Court looked at Article 1723 of the Civil Code, which says that if the building collapses within 15 years, the architects and the contractors are responsible, unless it was purely because of natural disasters or force majeure or measure. But the court saw that even before the earthquake, the building already had flaws, so the earthquake wasn't the only reason it collapsed. Under Article 1170, if you're careless and cause damage, that's a breach of duty, meaning both the architects and the contractors were at fault. They also tried to use Article 1267 or 1267, which says if something becomes impossible to do, you don't have to finish it. But the court shot that down because earthquakes aren't impossible to prepare for. They should have built the structure properly in the first place. A, commission, a commissioner's report confirmed that the construction was bad, the design had flaws, and UCCI didn't follow the original plan, so the court ruled both were liable. Moral of the story? Architects and contractors cannot just blame earthquakes when their work was already bad. So, in short, let me explain like in the most common way or casual way. Imagine you buy a brand new phone. You expect it to last a while, right? But after just 2 years, the screen cracks from a minor drop. You check and realize the screen was poorly made and the phone had weak frame. Now, do you blame the manufacturer for using cheap materials or the designer for making a bad blueprint? The Supreme Court treated this case the same way. Both the designer, or Nakpils, and builders, the UCCI, messed up, so they both had to take responsibility. The earthquake was just the final push. The building was already weak to begin with.